Next case is Susan Bisio versus the City of the Village of Clarkston.
It's not his normal lateness. How did Professor Friedman do? Yeah.
Morning.
Good morning.
May it please the court, Richard Bisio on behalf of the appellant Susan Bisio. And I would welcome your questions at any time. This case is about the records of a city attorney, but it has much broader implications than that. The theory that the city advocates applies to all municipal officers and employees, and it would allow them to keep private off-premises files of records of their conduct of city business. And we're asking you to reject that theory and hold that city officers and employees act on behalf of their city. Now, the city wants to make a highly technical argument about the definition of public record. That definition requires that the record be prepared, owned, used, in the possession of, or retained by a public body. Their simplistic argument is, city attorney, he's not a public body, therefore he can't have any public records. That ignores the actual day-to-day operation of how a city does business. A city is an artificial legal entity. It can only act through its officers and employees. And when it does so, those actions are the actions of the city. The interpretation that the city proposes is contrary to two principles. First, it's contrary to the public policy expressed by the legislature in the first section of the Freedom of Information Act. And that section talks about people being entitled to know about the official acts of those who represent them as public officials and public employees. City, though, says, no, public officials, they're not public bodies. Employees, they're not public bodies. Therefore, none of their records are subject to FOIA.
Well, you must agree that hortatory language of that sort doesn't necessarily trump the actual language of the law, does it?
It does not, but it informs the court's interpretation if, for example, we have two competing interpretations of the law. Mm-hmm. I don't think the city's is reasonable or logical, but if you're going to consider the city's view on this, you should pick the interpretation that furthers the policy of the statute rather than...
Can I ask you, counsel, whether I'm focusing on the word owned in the definition of public record. I haven't seen quite as much emphasis or focus upon this provision as I've seen on some other provisions. Is there any fair sense in which it can be said that this definition is applicable to this case and that papers in the possession of a constitutional office of a municipality, you see a charter office of a municipality, papers in the possession of that attorney are fairly owned by the client? I mean, I look at the third restatement, and the third restatement suggests that there's a right generally of access that clients have to the documents concerning their case held by their attorney. Is there any sense here that the papers were owned by the municipality despite being in the venue of the of their city attorney's office?
Absolutely.
We make that argument if you agree with
And I think that hones in on the practical realities of what goes on here. The city attorney was conducting city business, and they admitted that in their responses to requests to admission, and performing an official function of government of the city. He billed the city for his work. The city paid him. He testified that if he were replaced by someone new, he would transfer those files to the new city attorney. Obviously, they are the city's files and the city's records.
But to suggest that the municipality has access or a sense of entitlement to the documents, is that fairly described as being equivalent to ownership?
I think it is. And the question of where these documents are, if they're sitting in the city attorney's private file versus sitting in City Hall, is a location argument that I don't think properly addresses the intent of the definition of public record. If you're going to focus on ownership, I think ownership means that the owner has the right to possession, even if they don't have actual possession, and the right to specify disposition of those records.
Why haven't you raised this issue? It seems like a fairly straightforward way of looking at things. If indeed it's the right way to look at things, why wouldn't this assist somewhat in focusing upon the municipality in a more straightforward way than some of the other terms that we've been focusing on in the same provision?
I think it's a good perspective, and if we didn't articulate it as clearly as we should have in our briefing, I apologize, but it's certainly a application of the definition of public record that goes right to the heart of what happened here and what happens in the normal course of all city officers and employees who are doing work on behalf of the city.
Can I ask you just one more question, please, Counsel? I understand that FOIA includes an exemption for information or records subject to the attorney-client privilege, and it says what it says, and that needs to be regarded. But is it in fact the case that municipal officials around this state should understand clearly that there is no confidentiality, no protection for their conversations with their lawyers in light of what some would argue is a fairly broad understanding of this exemption?
There are two concepts there that you raise. One is the record a public record? And that's the issue here. Once you ask or determine that it's a public record, then the question is it exempt from production? And that's the attorney-client privilege. In this case, the city attorney testified there was no privileged communications. And these are communications between him and attorneys representing persons adverse to the city. Yeah. That's not a privileged communication.
But if these public records were in private hands, they would still be subject to attorney-client privilege.
I don't believe so. If you have a communication that's between the city attorney and someone.
No, I say if they were in private hands and they were shared with the private client's attorneys, they would be protected nonetheless.
If you're talking about a communication between a client and an attorney, yes, there's attorney-client privilege there. But that's not what we have here. The linchpin of the city's argument, I think, is to say that the common law of principal and agent doesn't apply here. Anybody that I've talked to about this case is quizzical about how can it be the city attorney is doing something on behalf of the city and yet he's really not acting on behalf of the city because FOIA says he's not a public body?
What should we make of the fact that under the state subsection of public body, it talks about a state officer, but under the county, city, township, village, et cetera, subsection, it doesn't say an officer or an officer of one of those entities?
Why is there a difference in those definitions is your question.
I don't know, why is there a difference? Why does one say state officer and the other doesn't? You're saying, quite plausibly, that the city attorney of Clarkston, I can't, this confuses me, the city of the village of Clarkston, is an officer of that municipal corporation, right?
Yes,
Okay, that's a plausible claim. In some cities, the city attorney is an actual employee, right? Here they've outsourced that function to a private attorney, which is common. It happens a lot. But I guess my question is, what should we make of the fact that that the listing for cities and townships and counties doesn't say an officer of those entities?
2 points in response to that question. First, we are not claiming that the city attorney is a public body. Obviously, he's not, because, as you point out, the definition doesn't include officers and employees of municipalities. But secondly, the fact that he is not a public body doesn't mean that he cannot possess a public body's public records. And if you want an explanation for why there's a difference in those two definitions for state.
Well, no, that's fine. If you're saying he's not a public body, so that's fine. You're on the agency theory that you just alluded to. Is that right?
That's right. And
So why would well, let me just ask some questions. I'm trying to understand your argument. The legislature went to a lot of trouble to tell us who's a public body that's subject to a Freedom of Information Act request, right? And there's a lot of detail on these, in these 4 subsections of the statute. And I guess my question is, would there be a substantial overlap of a lot of these categories if we were to conclude that what the legislature really meant was these, the governmental entities and any agents of those entities? For example, why would it have to say an employee or department or bureau? All of those are agents of the state in a traditional agency sense, are they not?
Yes.
So why would the state or the legislature go to all the trouble of detailing all these particular entities and individuals who should be considered public bodies if what they meant was the government and all of its agents? Why didn't they just say that?
There is a difference between the definition of public body and public record. And to focus on the definition of public body is to miss what this case is really about, I think. Now, they may have, and this is speculation because there's no legislative history that sheds light on it, but may have made a difference in the definitions for state versus municipalities because the state has more resources, it's broader, it's bigger, and the definition of public body directs people as to whom they can send a request, and it imposes legal obligations on that public body to publish their FOIA guidelines and policies, to formally respond, to make estimates of costs and so forth. The legislature could well have thought that that's okay for employees and officers of the state because they have the resources of the state behind them, but we don't want to impose that on, for example, the DPW director of Clarkston or one of the part-time employees who cuts the lawn in the park. There are a good number of municipalities, I think more than 1,800, most of them very small. So there's a reason for making that distinction. But the reason is not to make public records outside of FOIA just because an officer or employee of the city handles those public records. And how could it be otherwise? The city is an artificial legal entity. It can act only through its agents, its officers, and its employees. If you're going to exclude whatever they do in determining whether something is a public record, then virtually nothing is a public record in a municipality. And I don't think it is reasonable to draw that inference from the difference in these definitions. The legislature knew how to exclude things and exclude particular individuals. Part of that definition of public body excludes the governor, the lieutenant governor, employees of their offices, and the county clerk in the capacity of clerk to the circuit court. So the legislature knew how to exclude people, and if it wanted to exclude officers and employees of municipalities, it could have said that. It is not reasonable to draw an inference from the difference in those definitions, which deals with public body, to say there are no public records if a person who's not a public body handles those records.
So who gets swept in if we accept your rule? I look at the Hoffman case that was cited in the briefs, and I think that related to an architectural firm or an engineering firm, civil engineering firm. I can't remember which one.
The Hoffman case involved an attorney.
Or was an attorney?
A private attorney who was retained by a school board to do an
Oh, yeah, right,
investigation.
I'm sorry, I'm thinking of another case, but-
District's finance department.
Right, I'm sorry. So, but let me go back to like a civil engineering firm, for example, that the city contracts with. Under your theory, are all of their files subject, for work they do for the city, are all of those files also subject to a Freedom of Information Act?
We are
What?
not advocating a bright line, inflexible rule.
Well, that doesn't work for us, because
you
once
have-
we say that if it impacts any agent of a municipality, including third parties that the municipality or any of the, anybody associated with it contracts with, that is a bright line rule, isn't it? In other words, let me ask you, what rule are you proposing that we adopt so that everyone in Michigan knows where the line is drawn?
The rule should be, look at the definition of public record and determine if the particular factual circumstances of the case fit that. Certainly it does with a city attorney and probably with most officers and employees of the city. Now, the city has this parade of horribles that they're
But how do I
saying.
get to city attorney and not to city engineer and all the other vendors that the city contracts with, particularly
Well-
professional services vendors?
One of the parts of that definition is that the record has to be used in the performance of an official function of the government. Now, the city of Clarkston contracts out to a private firm its building department function, so that the building official is a guy who's employed by a private firm. Is he performing an official function of government? I think yes. But they suggest, for example, we're going to draw in the
Just so
tree
we're clear,
trimmer.
just so we're clear, all of the records of that company that contracts with the government to do that, those are all public records subject to FOIA?
The records that are compiled in the course of performing the official function of being a building official, yes. Those would be building permits, inspection records, ordinance violation issues, and things of that nature. They certainly would be
And
public
is that
records.
regardless of where those records are maintained or who maintains ownership of them, et cetera? It seemed to me, I don't know how that arrangement exactly works, but I mean, for example, does the city maintain copies or the original of the building permits? that the city
I
issued?
don't know the answer to that, but I believe most of the records are probably in the firm that contracted to do this work. But the location doesn't make a difference. The Mackenzie versus Wales Township tells us that involved a computer tape that was prepared by a contractor that was never in the city's possession, but the city used it to send out their tax bills, and therefore it was a public record, even though the city never had possession of it. And the converse, of course, is true, that just because the city has possession, it doesn't necessarily mean it's a public record if they're not using that record in the performance of a public function. But I want to come...
What should we make in public record? Justice Markman asked you about this, of the fact that it says a writing, prepared, owned, used, in the possession of, or retained by a public body. There is the further limitation, you said, in the performance of an official function, but it does not say, for example, like our discovery court rules say, in the custody or, possession, custody, or control. It's not as broad. It just says owned. I guess the ones we would look at are owned or in the possession of. What should I make of the fact that it doesn't say in the possession, custody, owned or in the possession, custody, or control of a municipality?
The answer to that is right in the statute, which says public records, if they satisfy the definition, must be produced regardless of the location of the record. That's section 15.240.
Well, that makes sense. If you own the record or you have possession of it and the city has a warehouse, for example, where they maintain their records. But why does that get to records that they don't own or that aren't in the city's warehouse?
If they are used...
They're not in their possession.
If they are used by the city in the performance of a public function, that brings them within the definition of public record. And that's the McKenzie case. In that case, the city never had possession. It never prepared the computer tape that the requester wanted. It was in the hands of a contractor. The court said, either authorize the contractor to release it or get it and give it to the requester because
that's sort of inextricably intertwined with your agency article, right? Because our argument, because the definition says used by a public body in the performance of an official function. And so in your argument, I just want to make sure I understand it, is that the use of that document by the city attorney, we should interpret that to be use by a public body in the performance of an official function.
Absolutely.
Under an agency theory, is that right?
Yes, because in the case of a municipality, which is an artificial legal entity, they can only act through their agents. But let me come back to the substance of your question, though. Does it apply to any agent? The question that you have to ask in that situation is that agent performing an official function of government? They suggest, for example, the tree trimmer is going to be subject to FOIA requests. Well, is cutting off dead limbs of a tree an official function of government? I suppose you can argue one way or the other in terms of maintaining the public park or something like that. But that's an issue at the boundaries of this question. What we're talking about here, and you don't have to decide anything further than officers and employees of a city. Certainly they are agents of the city, acting on behalf of the city, and have the ability to possess the city's public records.
I feel a little bit like your argument is that the legislature didn't think about this at the time, but if they had, they would have written the statute differently. Is that a wrong thought that I have, or?
Well, when I started this case more than 4 years ago, I never thought that they would make this kind of an argument. I suppose you can try to twist these words in the definition of public body to say public bodies are only...
Well, you say twisting the words. I mean, the legislature could have said, or any agent thereof, right? I mean, they could have said, they could have written in black and white your argument, right?
They could have
You're
done
asking
that.
us to adopt.
They could have done
said,
that, but my
they could have
argument...
said, or any officer or employee thereof under sub 3, like they did in sub 1. I mean, so I guess I say that to say that it's not as though they're twisting the words and, they're saying, apply the words as they're written. You're saying, no, apply a more common sense, take a more common sense approach. Isn't that kind of what we're doing? You're saying my approach is more in line with the purpose that's been expressed? But I just say that when you're talking about who's twisting the words, I don't see either side twisting the words. What we're grappling with is what do the words mean and how much room to maneuver is there when the statute doesn't say exactly what you're urging us to adopt as an interpretation of it.
I think the premise of what you're asking is the wrong focus, not on the focus of what is a public body. The question here is what's a public record? And the definition of public body defines who you make the request to, who has the legal obligation to respond to it. But it does not limit, and as a practical matter, it can't limit what's a public record, except that the definition of public record says it has to be used, created, et cetera, by a public body. But when you're talking about an artificial legal entity, the city itself, as an abstract legal entity, doesn't create, use, or prepare records. That has to be done through people who work for the city and carry out the city's business.
I'm trying to figure out how we can agree with your rule and your interpretation without saying that the definition of a public body is equally affected to mean that it's all the things listed in any of their agents, because that's what you're urging us to adopt in the definition of a public record as it relates to a public body. And so I think, as I understand it, you're saying your agency argument should only apply to public body in the definition of what's a public record, but we shouldn't apply that same definition to public body, to the definition of public body itself? Is that what your argument is?
Yes, it is.
That's a little hard for us to do, isn't it?
No, not at all. Public body defines who you make the request to, who has the legal obligation to respond. And there are a whole bunch of other obligations under the Act that require the public body itself to do something. But it does not limit what's a public record. You got to look at the record, the definition of public record to determine that. And yes, it requires use, et cetera, by a public body.
So let me make sure I have this right. Agency principles don't apply to the definition of a public body in H, but they apply to the definition of a public body in I?
Yes.
That's hard for us to do, isn't it? We have to be pretty flexible.
I don't think so at all, because the legislature decided who you make a request to and who has the legal obligation to respond to it.
That makes some sense to me, that your explanation there. I'm just having a hard time applying the rationale. I don't think we can just apply it, traditional agency principles, to one subsection of a statute but not to another. And I'm afraid that if we apply it to both, that it could lead to unintended consequences. So.
Well, I'm not asking you to apply it to both. And the question is, what's a public record?
But the next person in the next case is going to say you just applied it to subsection I, so obviously the same rationale is going to apply to subsection H. You see, you might not be here, but we'll probably all be here, and we'll have to contend.
That would be an expansion, a judicial expansion of the definition of public body, and we're not asking you to do that. We're
Except
asking
when
you,
it comes to who maintains a record, then you are asking us.
well,
to do that.
we're asking you to apply a common sense and legal principle to the definition of public record. Action by a public body has to include action by its officers and employees. That's the only way that FOIA makes sense as applied to cities. And during the 40-year-plus history of FOIA, nobody's ever argued that municipalities don't have public records. But that's essentially what the city is arguing.
Mr. Tam he's very creative in his arguments.
I give him credit for that.
All right, thank you, counsel.
Thank you.
May it please this honorable court, my name is James Tam and I represent the city of the village of Clarkston. What appellant seeks here is not an interpretation of the statutory language, but to add language to an unambiguous statute to expand the definition of public record under the Freedom of Information Act. This case was brought under the Freedom of Information Act, and in granting the appellant's application for leave to appeal, this court asked to address two questions: whether the Court of Appeals erred in holding that the documents cited by plaintiffs were not within the definition of public record under Section 2 of the Freedom of Information Act, and secondly, whether the defendant city charter appointed attorney was an agent of the city, such that his correspondence with third parties, which were never shared with the city or in its possession, are public records subject to FOIA. The Court of Appeals did not err in this case, because what the Court of Appeals did is determine that these documents were not public records within the plain meaning of the statutory definition. These were correspondence that were drafted, prepared, and maintained by City Attorney Thomas J. Ryan. They were kept in his private office. They were never shared with the city of the village of Clarkston. No one at the city of the village of Clarkston ever acted upon these communications that Mr. Ryan had with third parties. So in that sense, the court did not in any way err in its determination of whether or not these documents were public records. The statute defines a public record as a writing that's prepared, owned, used in the possession or retained by the public body in the performance of an official function. So it's not merely that the document is possessed by the municipality, it has to be used by the municipality in the performance of a function.
What was the point of preparing the documents? Like, why would he even do this in the first place?
Well, Justice Bernstein, Mr. Ryan was hired to provide advice and consult on behalf of the city. These were communications that he exchanged preliminarily before he was within his private office setting, ultimately to provide advice to the city. So the documents themselves, as the court noted in Hoffman, those documents were part of his private office that he was going to use to ultimately provide advice to the city at a later date. And as Hoffman indicates, the fact that
But what was he? Like, I mean, you don't believe he was serving as an agent? Like, what was his capacity in that context?
Well, you're on set that I don't believe. Well, one, an attorney may act as an agent, but merely because one is an attorney doesn't make that person an agent under all circumstances. Additionally, Your Honor.
But what would he be then?
Well, he wouldn't be he would be what's defined. He was not a public body as defined by the statute. The statute specifically says what a public body is and what an entity is that is subject to the act. But
what would he be? Like, how would you define him?
I would define him as an attorney that's retained on behalf of the city of the village of Clarkston to provide them with legal advice. And moreover, Your Honor, the city charter, which plaintiff relies on, and which, of course, the act itself does not refer to the word charter. The act itself nowhere uses the word agent. And if we're going to rely on the city charter, which I think is what plaintiff or appellant argues, the city charter simply says that the city of the village of Clarkston may appoint an attorney to act on their behalf, and in that responsibility, the attorney is to advise the city, is to be a legal advisor, but nowhere within the definition, the charter definition of the position of city attorney, does it indicate that the city attorney is obligated to maintain records on behalf of the city, to provide those records on behalf of the city. And so if we're going to go down that road, which I don't believe we should, because it's not part of what the statutory definition is of.
Surely the city attorney has an obligation as an attorney to maintain a file on behalf of the client.
He does, and I think Justice Viviano, the city attorney also has a responsibility to keep the client advised of what he does. But
and to provide that file upon request, right?
He may provide that file upon request, but in this specific...
He's ethically obligated to do that, right?
He is if he's asked, but we know in this case, and it's undisputed.
Would you say that his file's under the control of the city?
I would say if the city requests it, that he would provide it. But in this particular case, the city never asked for it, the city never used it, and that's
So it's up to the city to decide whether or not it's a public record by whether or not they asked to receive the document or not?
Well, Justice Kavanaugh, it's how the record is defined and how the statute defines a public record. And the way in which the statute defines it is whether it's been not just possessed or used by the city, but in addition to that, the city's relied on it and has used that document in some way to perform an official function.
What do you do with owned?
Well, here's what I do. What I think what I do with owned is it's not owned by the city in the sense that there are documents that he relies on in providing advice, and that it becomes owned by the city if the city asks for production of that
Even
document.
though the city paid for it, right? He billed the city for it. It was an itemized list on his bill. The city decided not to ask to see it, but had they, he would have been obligated to turn it over to them. But because they didn't, they don't own it.
Correct. And had they sought it, it's undisputed from our perspective that if the city had asked for the documents, or if Mr. Ryan had produced documents, provided them to the city, and they used them and relied on them, that they would be public records. But that's not what happened here. Attorney Ryan had communications in order to formulate opinions or advice that he was going to give to the city, and the city never requested them. And as we know through the deposition of Ms. Eberhard, who was the city manager at that time, she didn't want this information. She was relying on...
I understand that she didn't want it, but because she didn't want it, therefore somebody who does, say a member of the public, who thinks that they should be entitled to, that her desire somehow takes it out of the realm of a public document. I mean, do you admit that there's a problem that reasoning is subject to manipulation?
I do not. And because not everything that's within an attorney's file is owned by his client. And I think that's the way that Michigan law has perceived it. And
hypothetically, couldn't someone then say at this point, wouldn't it be advantageous for the lawyer to say to the city then, you probably don't want to ask for this? Could they not prepare a file, and then hypothetically, wouldn't this encourage a circumstance like this where the lawyer says to the city, I've got this file, I've prepared all these documents, I've done an analysis as to what the question you've asked, I don't think you want to see it?
No, Your Honor, and here's why. That issue came up in Hoffman. And in Hoffman, the Bay City School District used its own retained attorney like the City of the Village of Clarkston did here.
Right.
And in that case, they specifically asked the attorney to prepare and perform an investigation,
right,
which the attorney did. The attorney provided advice to the city based on the investigation that he did, but the documents were never provided to the city. And the Court of Appeals determined that under those circumstances, those documents weren't public records, right, because they weren't possessed. And Justice Bernstein, it's not just that they possess them, they have to use them in some way. And that's within the definition of public record.
How do they have to, what do
they have to use them? Or can they use them? Can they possess them and be subject to the act, even if they don't use them? It's any one of those words.
No,
correct?
I don't think it's any one of those words. I think that they have to use them, that a public record means that it's prepared, owned, used in the possession of, or retained by a public body in the performance of an official function. If it's not used in the performance of an official function, the fact that it's owned.
But used is one of several terms separated by or. So
Correct.
it could be prepared by a public body in the performance of an official function, regardless of whether it's used. It could be owned.
But then again, Your Honor, it gets to the official function. And the city attorney, the function, he's ultimately providing advice. He's exchanging correspondence with people. It's not resulting, and it didn't result here, in any action that was taken by the city. So under those circumstances, it wouldn't qualify as a public record.
So would the city have an argument that they shouldn't have paid him for it?
Well, no, and the city did pay him for it. And just like in Detroit News versus City of Detroit, the public record in that case was, and the way that we got here was that Mr. Ryan's bill was submitted to the city. It itemized all of those things that he did for the city. So that was the public record, and the city had an understanding, and they paid it. But in Hoffman and in cases that Hoffman relied on, including the Forsham case, which is a United States Supreme Court case, they've indicated that merely because a municipality pays for, or a government entity pays for a service, it doesn't mean that they own everything that is within the scope of the services that are provided.
So you referenced earlier, and I think, and I apologize, I think we maybe cut you off before you finished your answer, that that an attorney is not obligated to turn over all of his file to a client, and that is somehow acts as a safeguard around, or to prevent sort of manipulation by the client just not asking to see it. Can you explain that a little bit further?
No, I think the law in Michigan is that the attorney owns the file of the client, and that not everything within in an attorney's file is the client's. So in that sense, I don't think that it's owned by it. And in this particular case, because it doesn't fall within the definition of a public record, because the city never possessed it or had or used it, and that's where the Court of Appeals.
Can you explain to
rely.
me what's the distinguishing feature between what is owned by the client and what is not in an attorney's file?
I can't, Your Honor,
Okay.
other than to say that, it's my understanding that not everything that would be within the attorney's file would be owned
Would
by the
belong
client.
to the client.
And that, and that certainly wasn't something that Mrs. Bisio relied on in saying, hey, they own this, and that wasn't what we were, that wasn't their focus certainly before. But I don't think that based on Forsham and based on the language that's in Huffman, Huffman said that attorney's file was not a public record because it wasn't provided to the municipality or in that case, the school district. So I would rely on that case and as well as Briner that indicates that they weren't public records.
What does that mean to be used? How much do they have to use it?
I think they would have. I would think that they would have to take some action upon it, Your Honor. That Justice Bernstein, it's not that they would have to form a decision, take some action upon it, and in this case, they didn't. It wasn't something that was shared or relied upon, as the court noted in its in the application granting leave to appeal.
Are you appropriately conflating ordinary attorneys with the city attorney? Isn't the argument that a city attorney is something different? It's created by the charter. It has an official obligation to the client, to the municipality. Are you suggesting that the ordinary relationship between client and attorney also characterizes or properly describes the relationship between the city attorney, the official city attorney, and the municipality?
I do, Your Honor. I don't think that by being a municipal attorney that it expands the role or obligations of the attorney. And particularly with regard to this case, there's a relationship or definition of the city attorney's obligation that's contained within the charter. And the charter, which is part of the record, doesn't indicate that the attorney has to provide any of these correspondence to the city. It's nowhere within the definition. And what it says is that the city attorney's responsibility is to provide advice to the city on all matters of changes in the development in the law, to act as a legal advisor, to advise the city manager, to prosecute ordinance violations, to prepare and review ordinances, attend meetings, defend officers.
I understand that, but paperwork and documents often accompany the city attorney in the course of doing the things that it's required to do. I understand that this city attorney represented several cities, not just Clarkston. I also understand that he represented private clients having nothing to do with the municipal function.
Right.
But to the extent that there were documents in his file that pertain to his representation of Clarkston specifically,
Yes.
isn't there some greater obligation, some sense in which it can be said there's a greater obligation than simply with regard to a private relationship?
I don't. I think he maintains an obligation to advise his client and keep them apprised of the things that he's doing, and when he believes it's appropriate, that to provide those documents to the city. In this case, the particular documents were not provided by the city.
Well, what do you make of third restatement, the law of lawyers? I know we haven't explicitly adopted it, so that would be a good response to my question here. But nonetheless, it says a client is entitled to retrieve documents in possession of a lawyer relating to representation of the client. That right extends to documents placed in the lawyer's possession as well as to documents produced by the lawyer.
Well,
if we have some suggestion within the law of our state that there's some sympathy with the restatement, would that change your thinking at all?
Well, it would not, because as you noted, Justice Markman, the state of Michigan has not adopted that. And additionally...
But I don't know that it's rejected it either.
But we're dealing with the words that the legislature enacted. And the legislature has, on multiple occasions, amended the Freedom of Information Act. In fact, during the pendency of this action, the legislature amended the Freedom of Information Act, and this court, in a majority opinion in which you agreed to, Justice Markman, in the Briner case, specifically noted that the language of the Freedom of Information Act does not extend to agents. Had the Supreme Court, or had the legislature intended to include agents, it would have done so when it had the act, when it drafted the act. It would have included agents within that definition, and it didn't do so. Moreover, this court, when it decided Briner, which was in 2001, and it specifically noted that agents were not covered by the bodies that were entitled or part of public bodies, the legislature did nothing since that time to amend it. So that would be my response, is to rely on we're here to interpret the language of the statute. The statute says what it says.
Well, I actually agree with that proposition in Briner remarkably. Despite actually joining the opinion, I agree with it. But I don't think that the language in the statute here defines a principal-agent relationship. I think it talks about agency in the sense of a subdivision or a compartment of government with the listing of things that precede it. But I do wonder whether, as in the federal realm, whether an agent is subject to FOIA only when the agent works closely with government and is tightly controlled in some respect by government. That was really the focus of my question a few minutes ago. This is an agent who's different from the kind of agent reflected or represented by an attorney who's just been hired for a single project. This is an individual who works closely and regularly and methodically with Clarkston and is presumably regulated and directed in significant part by the leadership of Clarkston. And to me, that seems to arguably at least make a difference.
Well, but in regard to that, Justice Markman, if the legislature intended to do that, they certainly could have. And that's what was noted in the Briner case, that the legislature was aware of the terms that it used the term agency in the sense of a subdivision, not an agent, and had it intended to use the word agent, it would have. Because it didn't, and the common law is not what's at issue here. It's the language of the statute itself that these issues were appropriately decided by the Court of Appeals.
So to respond, to inquire further of the kind of questions that Justice Kavanaugh was asking you, and that I think I broached earlier too. What exactly is the nature of the relationship between a municipality and its charter-based city attorney with regard to documents as to which the municipality has an effective entitlement? Maybe it's not ownership, maybe it is. What is it if it's not ownership?
Under those circumstances, Justice Markman, I would defer to what the city charter says the obligations are. And the city charter does not indicate that the city attorney is a record keeper or that he is to provide the documents that he maintains in his private office. So I think in that sense, you must look at the language of the charter. But I would implore the court that the legislature did not use the term charter. The legislature doesn't distinguish between a charter-appointed attorney and someone who's not appointed by charter. And had they wished to do so, Your Honor, they would have done so. And they would have done so in the multiple occasions that they've had these issues come up.
I'm not really focused in this question upon the nature of the city attorney's authority. I'm really asking a question focused upon the issue of what does describe this relationship, even if it was a private attorney, where you have let's say we had the third restatement in force here in Michigan, and there was an entitlement to documents, even in the files of someone who's not a city attorney, not a charter-based attorney. What legal relationship would describe that?
Well, here I think it's described by the charter itself, which doesn't require that those documents.
No, would it be an ownership relationship, a fiduciary relationship, a chance relationship? What would it be?
I think there's certainly a fiduciary relationship.
Friends, maybe
friends.
Acquaintances?
I think there's a fiduciary relationship that the attorney owes to the client. But with regard to the statute and the definitions, Your Honor, had the legislature intended to go there, it would have, it could have.
Mr. Tam, can I ask one last question? Because my colleagues are probably ready to move on to the next case based on that.
You come in late and then you just,
I had a lot of coffee and a lot of energy left over.
I
because
see.
didn't have to participate in the first case. So I just have one last line drawing question that I think is related to what Justice Markman was talking about. I think this, in urging the interpretation the plaintiff is urging, we have to think about how it will apply broadly to everyone in Michigan, because that's sort of our job. And so I was asking some questions about attorneys and other city vendors, how it would apply in that context. I think you just had a discussion with Justice Markman about private attorneys versus city attorneys. My question is, does it matter, would it matter, or in terms of the rule that you believe we should adopt, whether the city attorney is an in-house city attorney as opposed to an outside counsel type of arrangement like the one that Mr. Ryan apparently had with the city of the village of Clarkston?
Well, I think the difference here is that the city attorney is a private lawyer outside of the
It's
city.
not here. I'm asking a
I
general question about
understand
everywhere.
that. But
A lot of cities, some big cities, Detroit, Warren, Grand
Right.
Rapids, has corporation counsel, right? They're in-house, records are in-house. Let me just put a fine point on it. If somebody, I just talked to the corporation counsel in Detroit. So if the same request was made to one of their lawyers, would that information be turned over on your?
Absolutely it would be, because, Your Honor, under those circumstances, the city attorney is part of the city. Those records are maintained by the city. They're in the possession of the city. Therein lies the difference, and therein lies the statutory interpretation. And as Mr. Bisio indicated in his oral argument, municipalities don't always have the financial wherewithal. That's why they contract with vendors like city attorneys, and that's like they did in this case. And, Your Honor, the rule that he is urging you to adopt wouldn't just apply to attorneys. It would apply to engineers, accountants, planners, anybody that has a connection and provides services, because that argument could be made that they are owned by the municipality, even though they're really the documents that belong to the independent contractor.
That would sort of depend on the questions Justice Markman was asking you about whether the client's rights to the file, whether the city has the rights to the engineering file, or et cetera, because there could be an arrangement where the vendor says, you don't have a right to our information, we're only providing you whatever it is that they're providing, right?
Right, and the question, and it's in the application when leave was granted, saying the charter appointed attorney, and I would just note the term charter and appointed doesn't appear under the definition of either public body or public record. So had the legislature intended to do that, because as you noted, Justice Viviano, this is not an unusual relationship. It's been in existence for decades, where municipalities hire private lawyers, and had the legislature intended to broadly apply this to extend to agents and others, it could have done so. It did specifically indicate with regard to the state that it was officers and employees. It chose not to do so with regard to cities, villages, and the like. And therefore, I think that this expansive reading that is proposed is inconsistent with the plain language of the statute itself, and that the decision that the Court of Appeals reached was appropriate and should be upheld.
Thank you very much. Case will be submitted.